My Lord, Lord Justice Dingemans, just before lunch, asked me an exam question.
Oh, well, sorry about that.
And which was, I think, what was the genesis of, if you like, the claim based on innuendo meaning. I'm afraid our researchers over lunch have not yielded an answer yet, but we will continue to look.
Thank you for trying, and I'm sorry to ask you, but it's, I mean, given that this is the first time intrinsic and extrinsic has been used, but we were all well aware that there had been reference to false and true innuendos in identification cases. It's just where it came from. I mean, it may not matter.
We will continue to look.
Thank you.
The grounds of appeal, the first ground of appeal is that Mr. Justice Nicklin applied the wrong test. It said that he proceeded on the basis that the case fell into a previously unrecognised intermediate category of case, which depended on whether the claimant were the target of the allegations. That's the first ground. That, in our submission, is misplaced. Can I ask you, please, to turn to the judgment? The judge starts his analysis of the relevant legal principles at paragraph 17. There is nothing in our submission remotely controversial about what he says in any of paragraphs 17, 18, 19, 20, 21, and 22. Those are a very conventional summary of the relevant legal principles. And as I understand it, no criticism is made by my learned friend of what the judge said in those paragraphs. The judge was plainly very well aware of the principles that apply in assessing intrinsic reference. It is said, however, that the judge fell into error in paragraph 23, and what Mr. Tomlinson says is that the judge appeared to approach the case on the basis that NUTFA only applied in extrinsic reference cases, and that there is an intermediate category that the judge was identifying wrongly. Now, dealing first of all with what's said about NUTFA, paragraph 27 is where the judge raises NUTFA. And what he says in that paragraph is no more than what is said by Viscount Simon in NUTFA. And your lordships will note that that includes reference to persons acquainted with the plaintiff. And I mention that because there was a suggestion that that was an aspect of the test which the judge did not have in mind when carrying out the exercise in the current case. But he did. It's there, it's in NUTFA, and the judge explicitly cites it in paragraph 27. What is also said is that NUTFA, the judge applied NUTFA wrongly, or rather didn't apply it because he sought to distinguish it on the grounds that it's a case of extrinsic reference. There is no basis in my submission for that criticism. Where in paragraph 28 the judge says the underlined words are important, NUTFA was an extrinsic evidence or reference innuendo case, he is not saying that the underlined words are important, or rather that it's important that NUTFA was an extrinsic reference case. That's to misunderstand what the judge is saying. The judge is saying the underlined words are important because they demonstrate that the principles in that case apply where the plaintiff is not named. He's not saying some different principle applies where it's a case of extrinsic reference. He is not saying that. One would expect, if the judge were saying that he would make that explicit. That would obviously be a radical departure from the decided authorities, and one would expect a judge with the experience of Mr. Justice Nicklin to clearly signal that. He is not saying that. And there is nothing in this judgment, in my submission, which indicates that he was departing from the NUTFA test. that there, at no point does he say he's applying a different approach to the exercise before him.
Well, I'm lost, because what is the significance of the underlining of those words where the plaintiff is not named within the judgment?
It's true, it's a little bit obscure. It's a little bit obscure exactly why he says the underlying words are important. But what is, in my submission, absolutely plain from what follows, is that he's not saying they're important because the case can be distinguished. He's simply saying it was an extrinsic reference case. He's not saying, well, it was an extrinsic reference case and therefore some different principle applied in it. In my submission, surely if he were going to do that, if he were going to say, well, the court has to approach the exercise differently, he would say that. That would be quite obviously a matter of great import. And he's not. And as I say, nowhere else in the judgment is there any suggestion that he did in fact seek to apply some different test.
Can I then, as you've said that in terms, just ask you about paragraph 21, and it comes back to this intrinsic and extrinsic definition. Because what the judge says, the identifying material may be contained in the words complained of themselves, brackets, intrinsic identification, which does rather suggest that the judge is leaving out of intrinsic identification persons acquainted with the plaintiff or claimant, because he's looking only at the words themselves. And I only put that to you simply because rereading it, that slightly worried me, and that's why I'd have asked you both so many questions about intrinsic and extrinsic and what's the true difference.
Yes. Well, again, those words may be capable of that interpretation, but read as a whole, in my submission, it is plain that this judge understands the exercise he has to conduct and the relevant applicable legal principles. They are clearly set out in 17 to 20 at the start. That's the rudiments of the test, the fundamental aspects of the test. And indeed, and of course, the judge is very familiar with this territory, because the other point he makes correctly is, and this is in paragraph 20, is the court will adopt a similar approach as it does when determining the natural ordinary meaning of words.
Well, that's the problem. It's not the same approach, is it? Nobody assumes any particular knowledge in the reader other than common general knowledge when they're considering meaning. But in this context, Knuckler says, and everyone's agreed, that the test involves imputing some knowledge of what everyone also seems to agree are actually extrinsic facts. So it's not the same.
Well, it's the same. It's the same to the extent that all the principles about loose thinking and the other aspects of the test, the
same except that.
To that limited extent.
Yes.
To that limited extent.
Yes. So the reasonable reader has all those characteristics of not being added for scandal, etc., etc., but is imbued with this, whatever this limited range of knowledge of the claimant is, in addition to common general knowledge. And that's the oddness of this.
Yes, how far it can go beyond common general knowledge.
Well, it must, because not everyone knows everyone. Not everyone knows Artemis Jones. Not everyone knows Harold Newstead of Camberwell. Probably very few people know Newstead of Camberwell. It was Obama, I think, or Obama. I can't remember which. These were not famous people. They're not the Prime Minister. And it's an oddity of this part of the law.
It's a feature of this part of the law, but in our submission, it's a feature that can't make a difference in this case, as I'll submit when we go through the judgment in a moment in more detail.
So actually, can I just put this to you? There's no big secret that I'm an outsider in this area of the law. It just strikes me as odd that there's this hard distinction which seems to have been created, whether it was created in this judgment or created as a result of a series of judgments, between what is being called now intrinsic and extrinsic. Because, to my mind, it feels and looks to me like a spectrum, really. In other words, you can have a case in which you really are looking at the meaning of the words, and in fact, you don't need anything at all. You just look at the meaning of the words. And now I'm talking about reference to work that out. There are then cases in which actually you need to remember that this is an objective exercise, and then there is an idea of some sort of ordinary common knowledge imbued that the ordinary reasonable person has in order to make sense of something. But then as soon as you do that, you're beginning to stray into the idea that you're imputing some facts, and you can imagine cases, I can tell you in my world, in intellectual property, we have these cases sometimes where you have a fight about what that kind of knowledge is, and ultimately you may not have evidence, or you may do. But then you then go further away, and you start saying, and in these company cases, as far as I can see, and what seems to be happening in the elite case, for example, is what is actually imputing to the reasonable objective observer one very important piece of knowledge, which is what the company does, which by no means would be ordinary common knowledge. But that seems to be the critical thing that was being imputed in elite, was that you approach it on the basis that you know what these companies do, or this any given individual company. But that feels quite extrinsic, or is it intrinsic? I'm not very sure. And then you have the much more extreme, obviously extrinsic cases, in which it really is a subset of people, and you really are saying these are very unusual facts, and you really need to prove evidence. And that makes sense to me, looking at it. Where it runs into trouble is by drawing this very sharp line, which has been created not in the substantive law, but in the procedural law, by having, for the best of reasons, a hearing where it matters a great deal whether you put it on one side of the line or another. And that seems, if I may say so, from where I'm coming from, to be what's happened here. And I just wanted to make sure that you could see that that's the way I'm thinking about it. And if you have anything you want to say about it, I'd be very grateful.
Well, the key point here, so far as the judge was concerned, was, as I said at the outset, assessing what information it was that the court had about the specific corporate claimants. That's the starting point.
Okay.
And when it comes to assessing intrinsic reference, there may be a case where there is more that the court is being invited to put into the mix in an intrinsic reference case. But that needs to be clearly signposted by the claimant, plainly. And your Lordship's right, there will come a point at which a decision has to be made by the court as to whether or not that case is made out, whether it requires factual evidence to make it out or not. But none of that applies to this case because, and that's why I started with it, the information that the court was given about these claimants was so extremely limited. Right. And therefore it was not possible for the judge to conclude, and we'll see when we go through it in a minute. The judge said, well, there might be a case that these claimants could advance, that ordinary readers knew certain things about them, which would enable them to advance a case of intrinsic reference. But it's not the case that I've got in front of me today. That's the core point about this case. There will be other cases where the judge either is able to do it because he's being presented with either evidence or pleading which is uncontroversial, the defendants don't take issue with it, or he says, well, I simply can't decide the question of what the reader acquainted with the claimant knows because it's contested. And that's a matter of fact. I currently can't decide. We need to give that more thought at some future date. But this wasn't that case. This case was an easier one for the judge for the reasons I've just given, because of the paucity of the information that he was provided with about these claimants.
But I don't want to take up too much time, but can I just put this to you? Taking what you're calling an intrinsic case, one party pops up and says, well, the intrinsic fact that the notional reasonable observer, reader, viewer would know is X, and the case could proceed. If the other party pops up and says, no, I don't agree with that, we're going to have a trial about that. Does that suddenly mean it's an extrinsic case? Because that's what it feels like has happened here. Because it is that the distinction extrinsic and intrinsic seems to have merged with the distinction of disputed and undisputed. And I don't think that's right, is it? That's not the right distinction.
Well,
You can have a dispute about an intrinsic case, even if you're disputing the facts that are imputed to the reader in the intrinsic case.
well, there is in an extrinsic case, what a claimant has to do is prove to the court's satisfaction that there was a subset of readers who had particular knowledge.
Cool.
And normally it will be fairly obvious. This was, I think, in answer to submissions I was making, in answer to questions I was being asked by my Lord Justice Warby earlier. Normally it will be obvious what that case is. It's a case where it's just, it's difficult to divine how somebody could know that these words talked about somebody, except if they had specific knowledge. It's normally, in practice, pretty straightforward to work out which cases fall into that category. It's undoubtedly right that there will be cases where it's much more difficult to ascertain whether a case is properly characterised as an intrinsic or extrinsic case. But my submission on this appeal is that it's not this case. This case is easily one side of the line. But we don't disagree with Your Lordship that there will be more difficult situations which will arise, although I think it's fair to say it's in practice pretty rare for that difficulty to come up.
Thank you.
So we say the judge did apply was aware of the correct legal test. There's no suggestion he was not aware of it and wasn't applying it. He was not distinguishing Knupfer and saying some different test applied in the extrinsic case. As for the criticism that he invented a potential intermediate category, this is paragraph 23. What the judge is plainly saying is these are examples of intrinsic reference cases which have particular features. And that is not controversial. So one example is the Channel 7 Pty Limited example, the David Jones example. And another example is group libel. So these are intrinsic reference cases with particular features, and that's all he is saying. He's not saying, well, there's a new category that no one's come up with yet, and there is a different test that applies in it. Nowhere does he suggest that that's the case. It's in my submission clear that he is proceeding on the basis that the test is the same in all reference cases, including this subset of cases with an intrinsic reference that have these unusual features that he describes in paragraph 23. So that, again, we say is a misplaced criticism of the judge. The reference to Palace Films we've already dealt with, the suggestion that the judge was wrong to derive any guidance from Palace reference, and Your Lordships will have my point that even if Palace was wrong, it doesn't matter because the essential principle is the same, and my submission uncontroversial. Next is the criticism that the judge introduced a novel notion of targeting. The suggestion that appeared to be made in my learned friend Skeleton argument that this involved an importation of a subjective element to the test, I think that's now fallen away. That's plainly wrong. He didn't. And as Your Lordships have seen earlier on, the word targeting is not new. This is not a new word. This is a word which the Supreme Court in Beaumont in Canada applied. So there is nothing in our submission about the way in which the judge approached this task, or the test which he applied, which is wrong. So that deals with the first ground of appeal. As for the second ground of appeal, this is, of course, an appeal against a finding of fact, and the threshold is high on any appeal against a finding of fact. First of all, it said that the approach was too legalistic, that the judge fell into error because his factual findings were too legalistic, but that's wrong. He looked at the case in the same way that Mr. Justice Eady did in Elite, and just as that was not an over-legalistic approach in Elite, it was not an overly legalistic approach in the current case. It said that the judge wrongly found there were two separate Dyson companies carrying out the relevant functions. That's in my learned friend skeleton at paragraph 64.2. It said that that, as a matter of fact, is wrong, but that is not what he said. We'll come to it in a moment when we go through the judgment, the relevant part of the decision in a moment, in a little more detail. And the it said that the judge was wrong to find that it would have been absurd for the claimant to suggest that the programme defamed all Dyson companies, that it could have just defamed the whole lot. That's what the judge found. Criticism is made of that. It's now clear that, in fact, this case isn't advanced on the basis that that is what the programme in fact did. So I'm not sure how far that criticism goes. Can we go to the decision? So obviously this is the real nub of it. This starts at paragraph 49. And in my submission, as we go through it, what it demonstrates is that what the judge was doing is, as I said before, seeking to identify what the words said, and therefore what the target of the words were, and seeking to marry that up with what he was being told about these corporate claimants, these specific corporate claimants in the pleaded case. So first of all, at 50, it said, Mr. Tomlinson's submission oversimplified the principles that apply to reference. The decision on reference is likely to be highly fact-specific, and apart from the most straightforward cases, is likely to require at least some consideration of the factual position. That is correct. So he is not saying that Mr. Tomlinson's submissions are wrong, and particularly with reference to NUTFA. He's not saying, well, Mr. Tomlinson was wrong to rely on NUTFA. What he's saying is the principles are more complex than Mr. Tomlinson has submitted. He then says it's possible that a publication could libel an entire group of companies, but such cases are likely to be rare. In most cases, the focus of the allegation, therefore the entity which is being referred to, will be readily identifiable from the publication. The touchstone of reference, as noted from the underlying passage from Duncan Hill, as quoted in Euromoney, is whether the person or company would be identified by readers as the subject of the allegation, as the target. That is, as I understand it, uncontroversial. That's the exercise he's performing. Mr. Tomlinson's stark admission of absurdity that the broadcast repeated reference to Dyson could be found not to have defamed any Dyson company can be contrasted with an alternative finding, arguably equally absurd, that the broadcast is found to have defamed all Dyson companies. The reality is, on a proper application of the principles of extrinsic reference, the answer is rather more nuanced. As I shall explain, the broadcast focus on Dyson may well give one or more Dyson companies a cause of action for libel. The question is which one. So he's not saying no company within the Dyson group has a claim for libel. He's saying, well, there may be one. He returns to this a bit later, but the decision for me is whether it's these two. The answer to that question, says the judge, requires a consideration of what is being alleged in the broadcast. Again, uncontroversial. My learned friend doesn't suggest that the judge was wrong to focus on that. It is not necessary to be found simply by looking at which Dyson companies have most connection with this jurisdiction. That's plainly right. And then he looks at the messages. The key messages the hypothetical ordinary reader would understand the broadcast conveyor as follows. The allegations centre on ATA, a Malaysian company that manufactures Dyson brand vacuum cleaners and filters. The allegation in the programmes are neatly crystallised in the introduction. Employees of ATA suffer abuse, inhuman working conditions, in one case even torture, and are paid £9 a day. So that's the starting point. That's the reveal of the programme, that these things are happening in ATA in Malaysia. Second, Dyson is an internationally recognised brand trading globally, but the experience of the workforce of ATA stands in contrast to the image that Dyson likes to promote. The key target is the Dyson company that has the agreement with, and therefore oversight of ATA. It's a matter of dispute between the parties. The gravity of the allegation. On this point, the complaints by Mr. Hall, that's the individual in the programme who is who's supporting the complainants at the factory, and the way they're responded to, including by Tom Crawford, described as Dyson's global director of sustainability, are a strong indicator of a Dyson company that's being identified of the broadcast allegations, at least so far as it concerns Dyson. And there we have the reference to the global nature of the company. And then at 4, potentially there's a further Dyson company targeted in the broadcast. That's the PR, the company that's responsible for the PR. The PR operation at the end of that paragraph may have been carried out by the same company as is alleged to have failed properly to investigate what was going on in ATA, but it could be a different company. So again, he's positing that it could be a particular Dyson company. It could even be one of the ones that's suing, but we don't know. And then 5, Miss Fry's interview with Michie, and I'm going to go through that interview just after I've gone through this part of the judgment, because it is very important, concentrates on the allegations of abuse of workers at ATA. As Mr. Wolanski argued, the repeated words of the use we, that's by Michie, would tend to indicate to viewers that Michie was speaking on behalf of whichever company had the commercial arrangement with ATA, an arrangement she emphasised had been terminated by Dyson. Again, that is a clear pointer to the viewer that it is the Dyson company that had the contract that is the target of the criticism. Now that is, in my submission, plainly right. But certainly it's a conclusion that the judge was entitled to reach. Miss Fry's questions then centre on why it took so long. Mr. Fry's questions then centre on why it took so long for Dyson to discover there was a problem at ATA, then repeats that Dyson should release the independent report that led Dyson to terminate his contract with ATA, before concluding the interview by putting it to Michie that Ms. Dyson was paying workers £9 a day to produce its products that could be on sale for up to £300. The interview does not deal with allegations of a cover-up of the PR operation. 53, this is obviously important. The broadcast allegations were not and would not reasonably be understood to be directed at the entire Dyson group. It is therefore not a case where every company in the group has a defamation claim arising from the broadcast. In my judgment, the ordinary reasonable reader, so there he is putting himself in the shoes of the ordinary reasonable reader, that is the correct approach, would identify 2 candidates as the subject of the broadcast. Again, correct approach. Which are the candidates that are the subject of the broadcast? So far as concerns Dyson, the corporate entity that was trading with ATA, and whichever company was responsible for the PR operation. Those companies may be the same, they may be different. The point the judge is making is he doesn't know, he's not being told, because the claimants aren't telling him which companies they are. If they are different companies, then each company may have a claim in defamation for distinct allegations. Depending on the ultimate factual situation, one Dyson company could have a claim based on some form of the claimant's first 2 meanings, and a further company have a claim based on the third. If the second and third claimants are not the companies that are the subject of the allegations broadcast, then they will fail to establish reference and will have no claim. So, again, he's saying if they're not the subject, because he's just not being given the information to make that determination. If the broadcast has caused any people to think less of the Dyson brand, and that's caused any loss to second or third claim, they're in no different position from individuals who cause loss by defamatory publication but are not referred to, and therefore cannot bring a claim. There may be other Dyson companies in respect of whom, based on facts pleaded and proved, the broadcast would convey a defamatory meaning if a reasonable person possessed of knowledge of those extrinsic facts. As yet, any other such candidates have not been identified. The short point is I cannot resolve these points at this stage. And again, coming back to where we started with the pleading, all the judge is saying is I cannot find in these claimants' favour on these points on the basis of the information they have given me. That's not to say there is no possible viable claim. It's just they have not made it out. 54. The issue I've had to decide in resolution of the first preliminary issue was whether, without consideration of extrinsic reference, the broadcast refers to the second and third claimants. For the reason I explained, it does not. The case is analogous to Palace Films. The result is the same. It may be possible for Dyson to put forward a revised claim on behalf of the current corporate claimants. So he leaves that possibility open. Or for claims to be brought by other companies in the Dyson group, the court will consider any reformulated claim that the claimants wish to advance. So the reason I've gone through that is because in my submission what it demonstrates is that the judge was putting himself in the shoes of the ordinary reasonable reader. He was identifying the target of the allegations, and then he was looking to see whether there was anything in front of him that could connect those allegations with these claimants, and he said no. That's his decision. He says that's not to say they could never have a claim, they might, but I can't see it here in front of me. And your lordships have seen the particulars of claim. My submission, not only was he entitled to carry out the task in that way, he had to, because the case just wasn't made out. Now, it is said by my learned friend, and he places a great deal of emphasis on this, that that the judge did not take into account the fact that the broadcast referred to the fact that these were that the Dyson was British. There was a Dyson, there was a British entity. If one looks at paragraph 56, about 12 lines down, this is dealing with what happens next. But he says this: the fact that these are the two companies of the Dyson group that operate and are the most prominent in the UK is not the point. Now, he's dealing here with a point about how the case may move forward, but I draw attention to that because he plainly has in mind that is the claimant's case. He's not overlooking it. He plainly has in mind that these are the companies of the Dyson group that operate and are the most prominent in the UK. And indeed, if one goes back briefly to paragraph 4, he cites, he doesn't cite much of the broadcast in paragraph 4, but these are plainly the 3 paragraphs he considers are most germane to the exercise he has to carry out. And the second of those paragraphs says that Dyson's slogan is a vacuum that doesn't lose suction, but has this iconic British brand lost credibility? So the judge himself firmly emphasises that is a key component of the broadcast. So he has it firmly in mind when he's carrying out the exercise of determining reference, that the words refer to a British company, and that Dyson says it is the group that operates, and the claimants say they are the parts of the group that operate and are the most prominent in the UK. So those are facts that he plainly has in mind when he's carrying out the exercise.
Sorry, I missed your reference. Which is the passage in which he refers to the iconic British brand?
That's paragraph 4, and that's the citation, that's the quote from the opening words of the broadcast. So, and as I say, he doesn't quite much of it, but he obviously considers that these are particularly significant parts of the broadcast. So it cannot be suggested in my submission that was something he simply overlooked. He didn't.
Sorry to interrupt. It was just the bit you've taken us to, the fact that these are the 2 companies of the Dyson group that operate and are the most prominent in the UK is not the point. Why isn't it the point?
Well, he's not addressing the exercise of determining reference looking back. He's talking about disclosing a case with a real prospect of success moving forward. And he says the relevant claimant must plead and prove the facts that would identify it as the company that is the subject of the broadcast allegations. So what he's saying is it's not good enough just to say, as the claimants did, these are the 2 companies of the Dyson group that operate and are the most prominent in the UK. That's the point he's making. That's not in itself enough.
Can I just ask you then to what the answer to the proposition would be that one reasonable viewer might read this: Dyson's selling goods made by workers in the supply chain employed by ARTA who are being mistreated, and Dyson should have known what was happening, and that's just picking out the words, and that's Dyson in the UK.
Yes,
should have known what's happening.
Can I address that point?
Yeah, of course, whenever.
Now, because I said I would come back to Michelle Shee.
Yeah.
Michelle Shee is key to the judge's finding of fact. It's key, and the reason why she's key to the judge's finding of fact is because she takes up the last part of the programme, a big chunk of it. Yeah. So I would like to therefore conclude with what she says, and that is in the the transcript the transcript is at tab 11. At page 142, we have the interview with Michelle, and as I say, it takes up a big chunk of the programme, and the programme finishes with it. So it's what the viewers are left with, if you like, the broadcast. Now, it's important because it moves the emphasis. Whilst it's right to say at the beginning of the broadcast we had the UK, Britain. Now, at the end of the programme, last few minutes are all about somewhere else, what's happening outside Britain. So, Matt Fry says, paragraph 56, Sean is sending with that exclusive report. Well, now I'm joined by Michelle Shi, who is Global Manufacturing and Procurement Director at Dyson in Singapore. So immediately, she's in Singapore. Thank you very much for coming on the show, and I appreciate you staying up till 3 in the morning to answer these questions. And not only is she Singapore, she's made the effort to stay up till 3 in the morning. They're serious questions. And so he then starts his questions. Dyson's company, Brits are incredibly proud of. How did it get to this? And Michelle Shi says, firstly, thank you for having me tonight, Matt. What we have seen, and your viewers have seen, are serious and concerning. They don't represent what Dyson stands for. Dyson has high standards in our corporate responsibilities, and we stand behind that. And I think in your report you talked about the audits that we have done. So what Michelle Shi is doing is she's owning what is being said in the broadcast about the group. Here she is in Singapore, the Global Manufacturing and Procurement Director, staying up till 3 o'clock in the morning, and she is taking ownership of these issues on behalf of the brand. 59, paragraph 59 further down, the 6 audits, she's been asked about these audits, between 2 years between 2019 and 20, the 6 audits we did, 2 were internal and 4 were by internationally recognised audit bodies. Every finding in the audit reports we did proactively drove improvement. The ATA factories, that's we, and it's only when ATA industries were not making these improvements at a timely matter that we wanted, and we terminated their contract, and we made the ultimate sanction to actually terminate the contract. This is the judge's point. The target of the allegation is the company that terminates the contract.
Well, we.
We.
There's a lot of weight being put on we. Why is we, in the judge's reasoning, by the global director of whatever it is, a reference to something excluding British companies?
Well, what the judge is saying is sorry to get back to the point. What the judge is saying it's a particular company in Singapore that is we. It's just in the light of that, he doesn't have the information in front of him to conclude it was these 2 British companies about which he's been told almost nothing. That's the point. Here's Michelle Shi in Singapore staying up to 3 in the morning talking about we. She's the global director of this international brand. The judge is saying, well, yeah, so here she is. Big emphasis, and there's more to come. Big emphasis on what's going on in Singapore, what's going on in Malaysia. The thrust of this is about the company that had the relationship with Dyson, with the supplier factory in Malaysia. And yet I'm being asked to find that these words refer to these 2 British companies about which I know nothing. That's the problem that he has.
Well, he knows they sell online, because if you look at paragraph 31, I mean, the interviewer brings it, 71, sorry, brings it straight back to the British company. You're selling these online for £180 odd, and you're paying your workers a pittance. Now, that may be a perfectly proper thing to complain to Dyson about, but it's talking about the Dyson in the UK which is selling, is it not?
Well, it's talking about global sales. If we get, sorry, I'll come to that, but if we just go back to paragraph, we were at 59, 60. Yeah. 62, Matt Fry's question is, you only terminated the contract in November of last year. It took you 2 years to make that decision. That's the one that led you to sever ties. And she then says at 63, well, 2 years, I myself, who lead this global supply chain for Dyson, and my team. So again, she's owning this issue.
But is the fact that she's in Singapore the key fact here? Because all of this, if she was somewhere else, if she was in the UK, all of these words would have no weight at all as distancing what she says from these companies. That's the location in Singapore.
But she's in Singapore.
Yeah, but she's the global director.
She's global director. She's in Singapore for a company, for that part of the company that is in Singapore. And not only is that part in Singapore, but she leads the global supply chain. So she obviously has, and the company that she is representing in Singapore, whichever that is, has responsibility for the global supply chain. So that's a big responsibility. Again, it comes back to the judge's point. Yeah. This is the target. It's the global. It's who has responsibility for the supply chain is the target, and she is saying it's us in Singapore.
Well, she's saying we.
We, and I'm in Singapore. So
would it be different if she'd been in Slough?
It may well have been different if she'd been in Slough. It may well have been, and yeah, may have been, but Dyson decided to put someone up for interview who's in Singapore for their own reasons. Then again in paragraph 63, working through the improvements, driving the improvements of the ATA industry, it's a very simple reason why we continuously proactively work with them. There are thousands of workers in ATA's factories, Matt. We simply just say, and then again at paragraph 55, well, we have the report. That's why we took the action. She's been criticised for not providing this audit report. More of the same at paragraph 68. Well, the welfare of the workers are our uttermost important priority. That's why we've been working with them, working on the actions. Matt Fry asks, is the welfare of the workers your utmost priority? At 70, well, Matt, that's the legal matter I cannot comment on, but we stand behind our corporate responsibilities and we have worked proactively with ATA to drive these actions. And now we have taken the ultimate sanction on ATA as well. So same point again. Which is the target of the broadcast? It's the company that has these dealings with ATA. That is the point. Then there's reference to the vacuum cleaners by the price of the vacuum cleaners and how much they cost. And my lord refers to the fact that this is selling vacuum cleaners. It's a global supply. It's a global company. This isn't specifically saying, well, it's only in the UK that they get sold. This is plainly a global company selling these these products everywhere. And Michie says, well, our products are the result of the technology, the innovation we put into our products. And then this, we are very much a global company. And we are in the global supply chain. And we very much want to be competitive in every market we are in. And in every market, not just Malaysia, there's the focus on Malaysia, but everywhere in the world, we want to be competitive. This is not about the UK. This is about what Dyson are doing globally. And if anywhere is the focus of this, it's Malaysia and Singapore. That's what she is saying. That's what she's making clear here. Then she's criticised for the very low pay of the workers in Malaysia. She says, paragraph 74, can't comment on the legal matter. Obviously, not taking advantage of the workers. We stand behind our standards. We've worked reactively. We take action, recognise our responsibility. We are doing that. We're going to continue to be doing that because the ethical supply chain for Dyson is what we stand for. And therefore, we're going to continue to work on for the benefit of the people there. It permeates what Miss Shee says, that she is the person acting in that country, representing that what's going on, what's taking place in that country. The company is there, the emphasis is there, and of course it was open to the judge, as a matter of fact, to say, well, despite everything that the viewers see about Michie and getting up at 3 in the morning and her going on about Singapore and Malaysia, despite all of that, there was a reference earlier in the programme to a British company, and therefore it referred, that none of that matters, what Michie says. But our submission is that it was plainly open to the judge to find the way he did find, which is actually the impression left on the reasonable viewer, because he's left with this long interview with Michie, is actually, this is all about what happens in Singapore and Malaysia. That's the company. that's where the action is, not in the UK. And as I say, it was Dyson's choice to put Miss Xi on as the representative and to have her get up at 3 in the morning. That is the impression that viewers are left with. It's a choice which they're entitled to make. It's a global company. They've offshored their products. That is their choice. But the outcome in terms of this case is that the judge was entitled to conclude, as a result of that, that viewers would have thought, well, this isn't actually targeting a UK company at all. And even if it were, I don't know enough about these two claimants to find that it was these two specific UK companies. Those were findings which this judge was entitled to make on the facts. We say, obviously correct to make. So on the second ground of appeal, you have my submission. On the facts, it's a very high threshold. On the facts, this was plainly a conclusion that this judge was entitled to reach on the facts. And there's no reason to interfere with it. Different judges may have reached different conclusions, but this was a conclusion which the judge was entitled to reach on the basis of these words. Well, I've slightly gone over my half an hour.
No, we've got plenty of time, and there is no rush. So
I don't know if your lordships have any further questions for me.
No, thank you. No.
Thank you very much indeed. Mr. Tomlinson.
Well, it's a valiant attempt by my learned friend to defend what is in reality the indefensible. The position is, my friend said halfway through this afternoon that there's no suggestion that the judge didn't apply the right test, and that was uncontroversial. I'm sorry to say that is entirely controversial. The judge plainly didn't apply the right test. He mentioned the fact that the judge mentions the right test once in passing and then says, I think he accepted rather obscurely that it was an extrinsic reference case. But nowhere in the section of his judgment where he deals with his decision does the judge consider the position of the reasonable viewer acquainted with the claimants. It's simply entirely absent from his consideration. It's very interesting that my friend said when he was dealing with the judge's findings of fact, well, the judge is marrying up what is said in the programme with the pleaded case. The remarkable thing is he doesn't mention the pleaded case about the claimants. He says nothing about paragraph 2 of the particulars of claim, setting out the nature of the claimant's business. And he says, although Mr. Wolanski sought valiantly to argue the contrary, he actually says nothing about Britishness either. So the crucial points in the claimant's case on intrinsic reference, namely, these are the companies in Britain that do the business, and this is a programme about a British company, are not dealt with by the judge at all. Which is, and to say there really is, we say, no cogent basis for arguing the contrary. The judge was focusing on an analysis of targeting. It was very revealing that Mr. Wolanski said this morning, and perhaps as a slip of the tongue, but when he was defending the judge's key findings, he said, well, the judge made these findings having read the transcript several times. And I'm sure he read the transcript several times. Of course, that isn't the right exercise. The judge is supposed to be doing what, as a matter of impression, the reasonable viewer would take from it on a single viewing. And that's exactly our criticism, that instead of doing that exercise, which the judge is very well familiar with in the meaning context, but instead of doing that exercise in the reference context, he's done a different, more complex, more sophisticated exercise. It's very interesting that Mr. Wolanski relies so heavily on elite, and the court will have noticed that in elite, Mr. Justice Eadie does not go through the broadcast looking for the key messages. He deals with the meanings, which by that stage had been the pleaded meanings, I think there'd been a capability ruling by Mr. Justice Morland earlier. But he deals with the meanings. And here, the judge doesn't deal with the meanings. He deals with his analysis of the facts, which is, as every libel lawyer knows, what matters is not the facts. It's what reasonable viewers or readers take from the publication. And Elite is an analogous case in the sense that it's about a group of companies. But of course, the court will also have picked up the point that we don't say, contrary to Mr. Wolanski, I have no idea where he gets this from, because we've never said the whole Dyson group is being libelled, which is what was being said in Elite, that the misconceived submission rejected by Mr. Justice Eadie in that case was that the whole Elite group was being libelled because they were all being damaged. We've never made that point. But our point is that, for the reasons which I've got into more than once, what was being libelled was the two British companies whose role, we say, is sufficiently pleaded in the paragraph 2 of the particulars of claim. Now, in retrospect, of course, it can be said, well, we should have pleaded this more fully. But as my lords, certainly my lords, Lord Justice Dingemans and Lord Justice Warby will know, Lord Justice Birss perhaps being less familiar with the arcanities of libel pleading. But this is the conventional way to plead a libel is, when you say it's an intrinsic reference case, is to plead these words were published of and concerning the claimant. And that's what we did. Now, the suggestion that somehow we've left Mr. Justice Nicklin in the dark because that's all we've pleaded, and we've pleaded the fact that they're British companies and they do the things that we say they do, is completely wrong-headed. We've pleaded it in the way that it might be expected we plead it, and we say that was the judge had more than sufficient information based on the terms of the broadcast, the pleading, to reach the conclusion that he should have reached, that this was an intrinsic reference case. The suggestion that the interview with Ms. Shi really casts any different light on this is frankly, well, remarkable. As I said sotto voce, that Mr. Fry begins.
Wasn't that sotto?
Wasn't intended to be. As Mr. Fry says at the beginning of his interview, Dyson is a company Brits are incredibly proud of. And then, as my Lord Justice Dingemans points out, he refers to the cost of Dyson vacuum cleaners in pounds, not in dollars or in. I've forgotten what the currency is in Singapore or Malaysia, but whatever it is, he doesn't refer to it in local currency. He refers to it in pounds. What's this broadcast doing on Channel 4 to a British audience? It's because it's of interest to Britain. It's not about Malaysia. It's about what British companies do or fail to do. So, my lords, we say that the position really is clear. The judge applied the wrong test, and had he applied the right test, he would have found this was an intrinsic reference case. Now, I realise, and I apologise, that I did not, in my opening submissions, expressly address the 4 questions that my Lord Justice Warby raised in his grant of permission to appeal. I think I implicitly addressed them, but let me explicitly address them, because it is important. And it's important also in the light of the point that my lords have been making about the soft-edged nature of this distinction, if I can put it this way, the spectrum, as Lord Justice Birss referred to. I'll come back to that in a moment, but the first question was what knowledge is to be attributed to the hypothetical persons acquainted with the claimant. And we say in our skeleton at paragraph 36, where we deal with it. We talk about name and repute, and basic but not intimate information. It's a point that is touched on in the authorities, as we've said. people acquainted with the claimant don't have perfect knowledge, but they know something about them, as most of us do about people or companies mentioned in the news, in the newspapers every day. We don't know everything, but we know something.
Does that have to be pleaded?
Well, can I come on to that?
Oh, sorry.
Answer that question now. Can I do it in terms of Lord Justice Warby's questions, if the court doesn't mind? The second question was, sorry, and it's not what everyone knows. It's crucial because not everyone is acquainted with the claimant. So it's basic information, not intimate information, that those acquainted with the claimant know. Not everyone. Secondly, the second question is, how is the court to ascertain what the hypothetical reader knows? Well, that is, we say, a dispute that, if there is in dispute, be crystallised on the pleadings. And one of the problems in this case that's arisen inadvertently, it's not nobody's fault, but the way it developed is because we pleaded it in the as it were, the conventional short form, and because there's no defence, none of these issues have ever been crystallised on the pleadings. But in the rare case where this kind of matter is in dispute, then that's how the court would ascertain, by resolving a pleaded dispute. And I say a rare case, and this is, I'm sure the court has this point, but it's important to emphasise it explicitly. This is very unusual. That basically it's almost always obvious which side of, whether it's an intrinsic reference case, and all name cases are treated as intrinsic reference cases, certainly in my experience, and I suspect in the experience of the court. If it's said that a wrongful act was committed by Mr. Dominic Raab, as an example, then everyone assumes that that's sufficient without giving any particulars of knowledge. On the other hand, and a classic extrinsic reference case would be taking the facts of this case. If the programme had said there's an iconic British company in the technology business that has factories in Malaysia that's been mistreating its workers, then what company is that? And the answer to that is only certain people would know that Dyson is a technology company with factories in Malaysia. That's not a matter of acquaintance, because that's a matter of specialist knowledge. And there are some cases in which only people with specialist knowledge will know who's being referred to. The cases don't go into this, partly because, as I said before, in former times, there was all the judge could decide was capability issues, not actual issues, and all these leading cases from Halton and Jones through to Morgan are actually what now be called extrinsic reference cases. But it doesn't arise very often. When it does arise, it could be crystallised on the pleading. The pleading burden, which is my Lord's third question, well, the pleading burden, as I said this morning and say again, if the defendant wants to say, no, you've pleaded this just as an intrinsic case, actually, it isn't. The defendant raises that in their defence, and the claimant deals with it in their reply, again, in the conventional way. And my Lord's fourth question was, how was that to be addressed in terms of case management? Well, this is one of those issues in terms of case management, unlike meaning, which can be determined, unless it's an innuendo meaning case, a natural ordinary meaning case can be determined without any evidence. But this is a bit like serious harm, which, as my Lords will know, was at one time thought to be something that could be dealt with as a preliminary issue, but required evidence, and now is thought in general shouldn't be determined as a preliminary issue. In the rare cases this kind of issue arises, it's unlikely it will be susceptible to determination as a preliminary issue. That being said, our primary position, and I hope I make this clear, our primary position is that on the facts of this case, there was sufficient material for the judge to make that determination in our favour. In other words, that this is an intrinsic reference case because of the key factors I've identified, the Britishness and the what are in effect entirely uncontroversial pleadings in paragraph 2 as to the nature of the claimants. If it turns out, if the case was different, I mean, if the descriptions were more complex and more controversial, issue was joined, then that would be a matter in the end would have to be determined at trial on the evidence. But we say that that's not this case because there was sufficient material there that had the judge applied the proper approach, in other words, not an over-sophisticated analysis. Secondly, taking into account the two crucial points I keep mentioning, then he would have come to the conclusion that the British companies being threatened with litigation were the two claimants, and he would have come to the conclusion that they were the, if I can put it this way, the wrongdoers, the bad guys in this story, which is why this was on Channel 4, why it was a big item on the news, why lawyers who looked like English lawyers were threatening litigation against them. So this is a case, and it's not that wouldn't be the case in every case, where it can be determined on the material the judge had. But we do accept the way that Lord Justice Birss puts it, that there's going to be a grey area. The boundaries. It's not a rigid boundary, because there's going to be cases where you say, well, is this person who's acquainted with the claimant, do they really have that amount of knowledge? Maybe some people have that knowledge, but some don't, and then it begins to look like an extrinsic case, not an intrinsic case, and then there's a fuzzy area in between, and we don't suggest that there's the court should say it's rigid, there's a clear boundary, but as I say, certainly in England, rather curiously, it seems to be a much more common problem in Australia. But in England, this doesn't seem to be a problem that's arisen very often historically. But, my lords, I hope that it's helpful for me to address explicitly those four questions that my lord raised in his permission decision. Well, can I just have a moment? My lords, unless I can assist you further, that's all I have to
Can
say.
I just ask, if targeting, one of your grounds of appeal complains about the judge's use of the word targeting, and Mr. Wolanski took us to paragraph 50 of the judgment, at the end of it, where the judge had said that targeting meant the subject of the allegations. If the judge had meant targeting in that sense, was that still an error?
Well, I think, my lord, I hope we put it fairly in our skeleton. What we said, it was apt to mislead. That it's the word target and the word subject and so on are factors you've got to take into account when you're. What does the reasonable viewer think? The reasonable viewer thinks, who is this about? And in one sense, they ask the question, who's the target? Who's it directed at? But once you start subjecting that to a fine analysis, and as the judge does, looking at precisely who's supposed to have done what and what contracts are supposed to have broken and so on and so forth, then you're led into error. And it's on that basis we say the judge, not that the word was wrong, so much as by emphasising it so much, the judge allowed himself to be led into error.
Second question, you referred to, you had pleaded in a number of places of and concerning. In your paragraph 5, I don't think anything turns on it. All I've got is of the claimants and each of them, which is another way of pleading it.
Yes.
You didn't see, there's no other part of the pleading.
No, that's, my lord, if I misspoke about that, I apologise.
I don't think it's a material misspeaking. The only reason it might have been material is that there was another bit of your pleading that I haven't worked out.
No. It's published, broadcast defamatory of the claimants in each of them. That's the,
And then the final question, Mr. Wolanski went over lunch to very kindly do a bit of research and came back with nothing further about where innuendo had come from, or extrinsic, on which the judge built up to intrinsic and extrinsic. Do you know where it was first mentioned?
I can. Mr. Helm thinks it first, the term reference innuendo first appears in a case called Bruce and Odom's Press in 1936. 1936, 1 KB 697.
Well, thank you very much.
As your lordship will know, that there's a distinction in true and false innuendo, which is usually used in relation to meaning innuendos, and certainly my recollection, having read through these authorities again recently, is that the term reference innuendo it starts appearing in the cases in the 60s as my Lord Justice Warby uses it from time to time, for example, in Barron and Vines, and says, "Oh, this is often referred to as reference innuendo." But there is certainly no case which systematically, as it were, sets out the use of the term and the best way to deal with it. Because as I think the court is aware, that these issues were examined by this court in Morgan and Odoms. I think Morgan and Odoms went to the Court of Appeal 3 times, but anyway, and in Jones and Holton, and in Knopfer. But it's very unusual for such issues to come before this court. So there's very little sophisticated analysis of the issues at the appellate level.
Thank you very much.
Yeah, one question. One of Mr. Wolanski's points this afternoon was, and I'm glossing, not quoting, that it can't be said that the judge would have found in your favour had he applied the right test, because paragraph 56 shows that he concluded that your particulars of reference, as to say innuendo reference, which covered but went beyond the prefatory averments, would not support a case of reference for the second and third claims with a realistic prospect of success. So in that context, although it's after he'd given his reasons, he assessed or expressed a view about the case on reference and said it wouldn't succeed. So that's right. Treating it as an innuendo case, he says it's hopeless and he strikes it out. Is that right?
Yes.
So what do you say to that?
Well, my Lord, that's premised on his analysis in paragraph 52. So
yes, it is. Yes, exactly. So it's your ground too, really.
Yes, yeah, exactly. So he's at paragraph 52. He's engaged in this subtle analysis of the program, rather than standing back as an ordinary viewer. And on that basis, he then takes the view that really what the program's about is a company in Malaysia, and so he therefore says, well, or rather, make it clearer. Sorry, my fault. It's about, in part, the company that contracted with ATA,
whatever that company
and whatever that company was. Yeah. And as we don't plead we contracted with ATA in our reference innuendo paragraph, it can't be us. But that decision is premised on his mistaken analysis several paragraphs earlier.
The real battleground may be whether the judge was, as Mr. Wolanski says, entitled to make the findings of fact that he did, or whether, as you say, he indulged in an over-sophisticated analysis, spending too much time on it and thereby departing from the conventional rules.
Yes, although I also think I make the point, I think I'm entitled to do it, that this doesn't look like a conventional meaning analysis. I mean, it's not as your lordship is very, very familiar with, that in recent years judges have become used to dealing with meaning and distilling meanings from long pieces of text. I dare say if a judge, the judge said those were the meanings of the programme, your lordship would be very surprised. It's not what you'd expect, because again, when one is doing a meaning analysis, one is taking the position of the, as we all know, the hypothetical, not avid for scandal, but capable of a bit of loose thinking, etc., reader, and then you take, as I put it, I hope helpfully, someone's thinking, what are they saying about these people? What's it about? What's going on? And it would be very odd indeed if someone asking themselves that question came up with those 5 sub-paragraphs.
Thank you both very much indeed for your considerable assistance, and indeed all those sitting behind and helping with. We'll take time to consider our judgment, and then we'll distribute it in the normal way. If you can cooperate and try and agree an order, that would be excellent. If you can't, then just short written submissions on the matters in issue. The judgments, when you get them, will be subject to the usual embargoes, and it would be very disappointing to have to lock anyone up for breaching them. Thank you very much indeed.